Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio every Saturday at 3 p.m. Today is June 22nd, 2024. And for those people who heard the song, it was by a group called Survivor. And the name of the song was The Eye of the Tiger. It was featured in one of the Rocky movies by Sylvester Stallone. Always loved that song. For all the first timers who are listening to this Zoom today, we have a format that usually I'll start with an opening topic, which I will do today. And then for those people who are in the Zoom meeting, and we have a lot also in YouTube Live, then we'll open it up to questions for those people in the Zoom meeting, and I'll give you some instructions about that. I've got a special topic today, and that is avoiding the tenant from hell. Yes, ladies and gentlemen, avoiding the tenant from hell. I can't tell you that every day we hear horror stories about these tenants. And just today, I was taking in a case from a client who had used me just a few months ago. We had evicted a tenant who was a nuisance, and she put a new tenant in. And of course, this tenant expressed that he had to get in very quickly, and he gave her a check for the full amount of the rent. He got into possession, and of course, the check bounced. And now we're having to do a regular eviction. In fact, the check didn't bounce. It was written on a closed account. You couldn't be more of a thief than that. So the question, ladies and gentlemen, is how do we avoid the tenant from hell? And I stood up a little PowerPoint today. So I'm going to start with that. The first thing you do when you have an applicant, most people would think that the first thing that you do is you give them an application. And ladies and gentlemen, that's not the first thing you do. So let's go to my PowerPoint, and let's see if I can get that going. First thing you do, I got to do the share. Don't forget that. Okay, thank you. The first thing you do when you rent out a unit is you take pictures or take video. Everybody has a smartphone. You want to see exactly what the condition of the property was prior to leasing out your property. So many times you'll have situations where tenants will walk into court and they'll say, look at all the bad things that are in my unit that the landlord never took care of. Well, if you have photographic proof or video proof as to the condition of the premises, when you get to court, it's going to show that, you know, something, all those doors were attached to the hinges. And you know, there were smoke detectors there, and there were no broken windows. So taking pictures is really important when you're going into a court of law and the tenant's claiming that everything was wrong with the premises. If you can show those pictures as to the condition of the premises prior to leasing it, you're well on your way there. Also, it's also good when you're doing the final security deposit itemization, and you're claiming that he broke that and this was broken, and this is obviously not ordinary wear and tear, it's unusual wear and tear. You now have proof based on your pictures. So that's the first thing that you're going to do when you're leasing out a unit. Now, I know the next thing that everybody's going to say is, okay, well, now you obviously give the tenant the application. And the answer to that is no, you don't do that. You need to start from the initial phone call. Before you even seen this person, you want to screen them right on that phone call. There's no reason to waste your time meeting with them, showing them the unit, giving them an application. You want to start right from that phone call. So how do you do that, ladies and gentlemen? Well, the first thing you do is you say to the tenant, why are you moving? Oh, it's so funny that you should ask that, because Dennis Block's evicting me. You see, right from there, you could say, I'm sorry, I don't take people who have been evicted. Or also you can say, for example, well, how many people are going to be moving into this 2-bedroom unit? And of course, the tenant might say to you, oh my God, I've got an extended family. There's 13 people that are going to move in. Well, I can tell you, ladies and gentlemen, you don't have to go any further. You could say, listen, I have a limit on how many people can live in my apartment. And by the way, fair housing, which I also like to call unfair housing, has a rule of thumb, and that is 2 per bedroom plus 1. So if you have a 2-bedroom unit, that would be a total of 5 people, a 1-bedroom unit, 3 people. But again, that would be your criteria. And you want to make sure that you follow that criteria. But if the person right on the phone is telling you, hey, we've got X amount of people moving in, then of course you do not want to go any further than that. So what's the next question? Well, do you have any pets? Oh my God, I got 2 Great Danes. Well, I'm so sorry. This is a no pet building. And by the way, do you smoke? Oh my God, like a chimney. I enjoy it. Well, I'm glad you enjoy smoking, but that's not something that we want in our building. By the way, every rental agreement should say no smoking anywhere on the property. I know that's contained in my rental agreement, and we'll talk about that in a couple of seconds. But again, you want to have your rental agreement that should say, we don't accept pets unless it's an ESA animal, an emotional support animal, or a service animal. And we certainly don't allow people to smoke in our property. Another one is, have you ever been evicted? Oh my God, yes. Well, you don't have to go any further. We don't accept any tenant who's ever been evicted before. And it doesn't matter that the tenant tells you that the landlord was crazy, was out of his mind, had the rent, lied in court. It makes no difference. If any landlord on the face of this earth evicted this person for any reason whatsoever, that's good enough for me. They're not getting into my building, and they shouldn't be getting into your building as well. Next question is, how's your credit? Oh my God, my credit's great. I just raised it to 498. Well, I can tell you that I'm so sorry. We have a criteria for renting out units, and that credit score is well below. And the last question you might want to ask is, do you have all the rent and the security deposit? Because if you don't have it, quite frankly, I'm not taking it in installments. That's a formula for disaster. So these are the initial questions that you should be asking the tenant right from that, or the applicant right from that phone call. Let's move over to this. This is where landlord's statement to the tenant. And this is to kind of get them primed for what you're expecting. And that is, hey, if you move into my building, you have to at least make 3 times the monthly rent. You must be able to furnish good references. You must have never had a bankruptcy. If you've had a bankruptcy, my position with bankruptcy is that it's moral theft. And on that basis, no one's moving into my building who's ever had a bankruptcy. I don't care how long ago it was. You will also need to furnish the required funds. So if the rent is $2,500, and unfortunately, as of July 1st, you can only get a 1-month security. So right now I'm going to need a total of $5,000 of security equal to 1 month's rent plus the first month's rent. If you don't have that, there's no reason to go any further with this. And the last thing is, now that we're limited come July 1st, with some exceptions, to a security deposit that only equals 1 month's rent, you need to raise your criteria. You need to raise your criteria for leasing out your units. I can't tell you that if you have a bad tenant, you're looking, by the time everything is done, you're looking at anywhere from $10,000 to $20,000 loss. By the time you get your attorney fees, the damage to your unit, the loss of rent, the trying to get another tenant in there, you've lost a ton of money. It is your obligation as a landlord to make sure that you are getting a tenant that's not going to cause you grief so that you have to call that magic number, which we all know what it is, 1-800-77-EVICT. So if you get yourself a good tenant, you're fine. Okay, so at least you're going to tell them now, because of the security deposit, that you have to at least get a 700 credit score. That's what my position is. And of course, you have to take things based on the economic conditions of your building, and you're desperate to rent it out. But again, having a bad tenant in your unit is much worse than having a vacant unit, okay? All right, let's move on. Questions you can't ask. Have you ever been arrested? Well, why can't I ask that question, you might say? Well, the reason is because you might have been arrested, but that doesn't mean you were found guilty. So it's only if you've been convicted of a felony. You can't ask people what their age is. That's a no-no. However, you can ask for a driver's license, and you can sneak a peek at what day they were born. You can't ask questions regarding their race, nationality, or religion, obviously. You can't ask questions regarding their disability. So if you see a guy in a wheelchair and this is an upstairs apartment and there's no elevator, you can't say, look, I don't think you're going to be able to make it up the stairs. We have no elevator. Well, don't ask. If he thinks he can get up there, that's up to him. The same thing with children. You know, I don't want children falling off the balcony, so I don't go there, okay? If they decide that they want to take that upstairs apartment, then as long as your building was built to code, you're fine. Obviously, you can't ask any questions about their orientation. And last but not least, you can't ask the great question, hey, are you planning on having children? Don't go there, ladies and gentlemen, because that's a formula to be sued. Let's move on. Other items, and I'm kind of going through this quickly so we can get to the questions. And that is you have every adult who is going to move into your unit fill out the application. Every single adult. There's the old adage that a chain is only as strong as its weakest link. Well, if you have a situation where the person with the worst credit is not giving you his application, what that means is you'll get half the rent from the good tenant and you'll still be shy half the rent. So every adult must fill out the application, and that has to be completed. And if it's not complete, then you're not even considering them as an applicant for your unit. On that application, it should also say, have you ever been evicted before? Has a landlord ever asked you to move? These are things that should be in the application. I know I have an application on my website, evict123.com, and you should definitely use something similar to that or that. Obviously, it's free. Every adult who's moving into your unit, you're going to do a credit check on. You want to see what their credit scores are. I don't care that someone is has a large or a high credit score. If another one doesn't, that would be grounds not to accept that tenant. By the way, if you do reject the tenant based wholly or partially on their credit score, you have to give them the name of the credit institution, their address, their phone number. You do not give them the credit report, but you tell them this is partially or entirely the reason why you didn't get the unit. And if you've got questions, here's the credit agency. Every adult who's going to be moving into your unit must sign the rental agreement. They must sign the rental agreement. Don't sign it first. You're the lord of the land. You're the landlord. They sign it first. And of course, on that rental agreement, it should also have a clause that says any misrepresentations on your application is considered a non-curable breach. And on that basis, we could do an immediate eviction. Again, I have a rental agreement on my website that has just been recently done, and it is really a great rental agreement. So please feel free to use that. And like the client that I had today who made that terrible rookie mistake, and that rookie mistake, ladies and gentlemen, was that she took the check and didn't wait for the funds to clear before allowing the tenant to move in. If you're taking any kind of an instrument, I don't care that it's a cashier's check from Chase Bank. People are giving counterfeit cashier's checks. They're in your unit and you're going to sit there and be trying to evict them for months, paying a bunch of money to my law firm, hopefully, or others, but do not let them in until that check clears. And again, you need all of that, the entire security deposit, the entire first month's rent. If they move in the middle of the month, okay, they moved in on June 15th, don't take a half month's rent plus the security. Take a full month's rent and the security, and then come July 1st, on July 1st, they'll only owe the proration. Don't take 15 days. You want to make sure you have as much money in your pocket before these people move into the unit. And last but not least, ladies and gentlemen, I'm going to show you one more frame. And if you just remember this last thing I'm going to tell you, you'll remember everything else, from the pictures to the initial questions, to the application, to the credit check, to the rental agreement. All you got to do is remember one more thing, ladies and gentlemen, and that thing is the last thing you do when you're leasing out a unit. The absolute last thing is you give them the key. If you give them the key, they have possession. So when the guy says, look, I just need to put my stuff in just for storage, you say no. If they saying, hey, I want to measure for the drapes, you tell them, I'll come in with you, but I'm not giving you the key. Anyway, that is my seminar for the day. Hope you found it interesting. We're now going to open it up to questions. Here's our ground rules. If you do want to talk to me, really simple. Electronically raise your hand on the bottom of the toolbar on the Zoom meeting. Do remember that these Zoom meetings are for informational purposes only and not a substitute for legal advice. And last but not least, if you have a case with me, I am very happy, but we do not discuss individual cases. We only deal with general questions. And based on that, I am going to open it up to questions. And the first person I see has a very short name, and it's Jay. Jay, I'm going to ask you to unmute yourself.
Hello.
Hey, Jay.
So I have a question. I have a co-tenancy. I have 3 unrelated individuals on one rental agreement, and I have one that is violating the rental agreement by smoking while on oxygen therapy. Can I evict just that one person, even though they're on one list?
Okay, there is no such thing as a partial eviction. So you're going to evict everybody or nobody. It would be like someone saying, well, 2 of the tenants are paying the rent and one, so I just want to evict that one. You have one rental agreement, you have one tenancy. It's a partnership. And if part of that partnership is violating a term of the rental agreement by smoking, you have to evict everyone.
How is that going to affect the other 2 roommates that are following the rules?
It's their fault. You know, they picked the wrong guy to be their partner, right? So, I mean, how would you feel if you only got 2/3 of the rent? You know, they all are responsible for the rent. They all are responsible for making sure that the terms of the contract are not violated. Maybe they need to put this person aside and rip that cigarette out of his hands. In any event, good question, Jay. I'm going to move on now to Jim Polina. Good afternoon.
Hello, Dennis. Nice to see you again. This is a nice habit every Saturday. I'm going to take your advice. I have this lease I've had for quite a while that automatically renews. I've done everything legal as far as the repetitive paragraph and so forth. So here's my dilemma. In the lease, it gives or demands a 60-day notice to not renew for both the landlord or the tenant. I'm down to within or around 30 days before the lease automatically renews. I need to give a 60-day notice to not renew. Am I too late?
I'd have to take a look at the contract, but the way you're saying it to me is that the notice of non-renewal had to be done 60 days prior to the term ending. Is that correct?
It doesn't say prior to the term ending. It just says 60-day notice.
Okay, well, then if it hasn't renewed yet, then based on the way you've written that, then I think you're okay.
Okay, so then after the lease terminates on July 31, then
Yeah,
it-
as
it's
long
just,
as it hasn't renewed yet, then I
yeah,
think you could serve a 60-day notice.
okay,
Again, any ambiguity in a contract goes against the person who authored the contract. So
great,
I don't know that I would have that term. I'm not a big fan of automatic renewal provisions anyway.
great.
But and you do have to have, as you realize, certain specific language and boldface type, and it's got to be in two places, one by the signatures. Very few landlords, Jim, have automatic renewal leases. So you are in territory probably all by yourself, just like the mountains behind you, young sir.
Well, I'm taking your advice. I'm going to month.
There you go. Thank you very much. Always enjoyed talking with you. We are moving on to Tony C. Tony C, say hello.
Hello, Dennis. Can you hear me?
I hear you wonderfully, sir.
So I can thank you enough for, giving your time and your knowledge to us, Thank you for that. Dennis, I have a situation here. I got a divorce, and after my divorce, I transferred my triplex that is under RSO. I transferred to my trust, and I have a old lease since 2011. In 2019, I asked all the tenants to sign a new lease agreement. So one of the tenants signed a new lease agreement, and he didn't include his daughter because she said she moved out. Now the daughter is back. She moved back to the unit, and she has an extra car. So I'm trying to find out what's my resource, what's my recourse to
Okay.
get this thing fixed.
So what you're saying is that the daughter was on the original agreement as a proper occupant. She moved out, and then when you did a new rental agreement, it was only his name and her name wasn't included. Is that correct?
Yes, that's correct.
Okay. And what city?
In LA.
Okay. I think the daughter doesn't have a right to live there anymore. So so you could ask that the daughter move at this point in time.
I have to give it a 3-day notice, right?
It would be a notice to perform or quit because she doesn't have any rights any further because the tenancy between the father and the daughter ended. And then for the last few years, you just had it with just the father. So if that person moves, you would have the right to serve a notice to perform or quit to have her move.
Thank you so much.
All right, good question. Okay, we are moving on to DK. DK, I'm going to ask you to unmute yourself.
Thank you, Dennis, for your wonderful videos. I watched the one on raising the rent last week, and I was a little confused. Maybe you mentioned it, but I didn't hear it. So my townhouse is in LA, it's RSO. And the question I have is, you said, I think what you said, I hope I don't misquote you, was that you can raise it to market rent. So mine is more than 10% below market rent. So my question is, if I raise it more than 10%, give them the proper notice, 90-day notice, there's this requirement now by the city of LA that if they choose that you raise it more than 10%, they choose to move, you have to pay them certain relocation fees, dependent, I think, on the number of rooms or something else. There's a bunch of requirements. So if I do raise it to market rent, they can choose to move. For my townhouse, do I need to pay them that relocation fee? That's what I was confused about.
And the answer is yes.
I see.
Okay, so all townhouses, condominiums, and single-family homes are not subject to rent limitations. Your townhouse probably was built prior to 1979, correct?
Yes.
So therefore, you are under the rent stabilization ordinance. Now, under this ordinance, they have instituted this policy where you have the right to raise the rent, but if you do and the tenant more than 10% and the tenant chooses not to accept that and say, I'm just out of here, they're entitled to relocation. This is a totally illegal law. The Apartment Association of Greater Los Angeles has already filed suit against the city of Los Angeles. I predict that they will lose miserably because this flies in the face of the Costa-Hawkins Rental Act. But right now, as it stands, you would have to pay that relocation. And it is based on the amount of bedrooms. If it was just a single family home, it's 1 month's rent. But if it's got 2 or 3 bedrooms, I don't know, it's like up to 8,000-9,000,
Yeah, it's a
something
lot
to
of
that
money.
effect.
So one follow-up, just quick. So quote unquote, if I want to avoid it, should I go like 10% or should I go like something like 9.8 or 9.9 or?
Well, you can do 10% without any harm.
Oh, okay.
If you go
10%.
above, then you're gonna get that harm. But between me and you,
Okay.
raise the damn rent to market level. You don't know what's happening. We've got this
Of course.
justice for renters on the ballot. And it doesn't matter that you're paying somebody $9,000. If you
Right.
can get an extra, and I don't know what you're getting an extra, but let's pretend an extra $1,000, right?
Yes.
You just want to do that. Number one,
Right.
it makes the value of your building so much more
Right.
valuable. And also you're just from an investment point of view, money in a bank, you couldn't get that kind of return. So
Yes.
don't worry about the relocation, which probably the tenant wouldn't even know of anyway. Serve that notice. And if the tenant leaves, good riddance. Thank you very much, DK.
Thank you. Thank you.
And we are moving on to, it looks like Al. Al, I'm going to ask you to unmute yourself. It says here, AL. Are you there, sir? Okay, I think we're asleep at the wheel. We're going to move on to Austin. I talked to you last week, Austin. How are you?
Good, Dennis. How are you today?
I am fine, thank you.
Okay, so talking about the tenant from hell and trying to avoid that as much as possible. Talking about the change of ownership form. The change of ownership form per California Civil Code 1962 gives like 4 options: cash, check, certified check, money order. And I want to give my tenants the option to do ACH or credit card or credit card. But I want that baked into the change of ownership form. After reading Civil Code 1962, I don't think there's anything that says I can't have those options in there. But as soon as I go modifying forms, the attorney from hell is going to pick that apart during an eviction. So
Well,
what do you think is the best way to do that?
well,
I close escrow on this 4-plex next week, and I want to do the change of ownership correctly.
okay, well, first of all, on my form online, it does say direct deposit, which is an ACH payment. So that's number one. You can also have a straight electronic payment like Zelle or something else. You can add that to the contract. But if it's just going to be a straight electronic payment, which is not like somebody if I give you my account number, you could walk into the bank and hand them your check and say, put it into this account, or you can do it online as an ACH payment. But if you're just going to have something like Zelle all by itself, then that's not proper. So I would keep my form that you have. You can add in also Zelle or any other electronic form of payment.
Okay. That sounds good. That's what my question was.
Very good, sir. And a good question. We are moving on to Harold. How is your one tenant doing, Harold?
I got good stuff for you. Hey, I wanted to tell you something real quick. My dad used to say that, we're always, whenever you take a loss, it's your tuition for screw you. So I'm thinking you can go to screw you or protect you. Dennis Blocks protect you. So I'm saving money talking to you. Okay, so here's the scenario. Let's say I want to get the tenant out, owner move in, and you give like it's a Los Angeles, what do they call it? Just cause.
Mm-hmm.
It's a 60-day notice. Can I safely count on 60 days, like anytime I want to do 60? Or I have to put it in place where I go to the city, wait for their approval, obviously see you, because I'm not going to do anything without Dennis Block. So time-wise, what do I look at? Is it way more than 60?
Okay, first of all, you're in the city of Los Angeles, correct?
Yeah.
And the reason why you want to evict the tenant is because?
Owner move in.
Okay, then yes, you have to first file the application process with the city.
Okay.
You don't have to wait for their approval.
Okay.
But it's just a good idea because the city is going to determine whether, in fact, what the relocation is. But for example, on a single family home, it's only 1 month's rent. I don't think there's much to determine. So
right.
So on that basis, you can just serve that notice. Now, I just learned something this week,
Oh, no.
which actually affects you in a positive way.
Oh, yes.
And because you live in the house too,
Right.
and you have no other borders, correct?
Nope.
Okay.
Nothing.
I'm happy to tell you now that you don't have to do anything with the city. It's just a straight, in this case, it's just a straight 60-day notice to get out, no
Oh, my God.
relocation, nothing. Because we tried to file one with the city this last week and they kicked it back saying you don't need to. And
Oh,
then we
man.
took a closer look at the rent stabilization ordinance, or actually the just cause ordinance. You
Okay.
don't need to file anything with the city. You don't need to serve anything other than a 60-day notice to vacate, just the standard one that you see on my website.
So in other words, the KGB, the deep state's not gonna come after me to make sure that, that all that bullshit that we talked about before.
No,
doesn't
you're
happen.
actually fine. And so I'm glad that you brought this up again. You just need to serve that. And if the deep state comes after you, you know what? You got me in your back pocket.
I'm still gonna hit you up before I do it. I'd rather pay the money, be safe, than get screwed at screw you.
All right, you got an easy way now. All right,
Love
thank you
it.
very much. We are going to move on to Michael and Sarah. Michael, what's the name of your realty company?
Oh, hello, Professor Dennis Block, the Chancellor of Block Law University of Landlord and Tenant Rights. Thank you very much for educating the young 50+ people. Well, I am California Golden Rock Realty, so we manage a lot of properties. So there is one property that is on the border of getting an eviction. So I will ask a question on that issue. But my main question is trying to have a tenant move out by my landlord due to property improvement. What kind of home improvements we're allowed in order to force the tenant to move out? And after improvement, what happens if the landlord decides to sell instead
Okay.
of tenant?
I think I
Yes.
got it, Michael. First of all,
Okay.
you have to tell me what city.
Oh, the city of Los Angeles.
Is this,
Tarzana.
okay?
Single family home.
It's a single family home with only one house on the lot, correct?
Yes, yes.
Okay, so you can do a major renovation and ask that tenant to leave. It's actually called substantial renovation. That's defined as work that takes longer than 30 days to complete, where the premises will be rendered uninhabitable for that 30-day period, and that the work that you plan to do would require a building permit. It's like an electrical or plumbing permit. So basically, if you're going to, upgrade the kitchen and the bathroom, you need to get the scope of the work by a contractor showing that it's going to take longer than 30 days. He has to pull the permits first. Once he does that, then we'll apply to the city and the tenant will have to leave. You do have to pay relocation, but relocation is only 1 month's rent. So you have an easy way of evicting this tenant from the single family home. Don't forget, if it is a single family home, nothing prevents you from just raising the rent.
Oh, okay, okay. Now that same tenant is behind the rent right now. If I serve a 3 days notice to pay or quit, the same form on your website.
Mhm.
Now, are you honor that if I want to start eviction?
Yeah, if you serve your own notice, then we'll certainly pick it up from there. Some clients do. They really make it difficult for landlords to properly serve a 3-day notice. There has to be certain notices posted on the property. You have to, the one on my website has the correct 3-day notice, but you have to serve a correct 3-day notice. You also have to fill out an eviction cover sheet and you have to send that into the city within 3 days of the service of the notice. So they build in all these traps so that landlords will lose their case. But if you have the knowledge to do it, and I do have a video up that's right by the on my forms on my website, right next to the 3-day notice, I actually have a video so you guys can figure it out yourself. But usually if you don't expect the tenant to pay, it's better just to have our law firm do it, and the fees don't change. It's the same fee whether we serve the notice, so we might as well serve it correctly.
Oh, okay. Okay. Well, thank you so much. I appreciate it. Have a nice rest of the day and tomorrow.
Thank
thank
you
you.
so much. I do have to say something about Michael. You know, you never want to get into a situation with renovation or anything else. If a tenant owes you rent, which is the only reason why you have a tenant, there's no other reason to have a tenant except to get your rent. If a tenant doesn't have a rent, don't go off onto these other tangents. We just need to go forward with an eviction based on non-payment of rent. That notwithstanding, we're going to move along to Gabriel. Gabriel, I'm going to ask you to unmute yourself.
Hi, Dennis. Thank you for your time. I appreciate it. I have a quick question for you. I'm closing on a duplex next week in Echo Park. And there's one existing tenant. One of the units is vacant. I want to owner occupy the unit that is currently occupied by the tenant. So I'll serve a, owner occupation. No fault.
Let me slow you down, young sir.
Uh-huh.
It's a duplex. Do both units have the same amount of bedrooms? Are you there? Hello? What happened? Gabriel, did I lose you? I think I did. I think you must have hit your mute button. Well, let me finish answering his question. I think here, I hear you. I'm going to ask you to unmute. Can you do it now, sir?
Yeah, there we go. Sorry about that.
Okay. Yeah, keep your fingers off the typewriter there. In any event, do both units have the same amount of bedrooms?
They do not. They do not. One's a 2-bedroom, one's a 1-bedroom.
If they were, then if they did have the same amount, then the law would require that you take the vacant unit. But since they're different, you certainly have the right to remove that tenant because you're moving in. However, there's more questions that need to be answered. And that is, the tenant who's living there, has he been there longer than 10 years?
No, 6 years. He's not disabled. He doesn't have kids.
Okay.
And now my
So,
question though, actually, because I know that I can go through that and it looks proper on paper and everything. My question is, I'm currently renting, an apartment while we're waiting to take that one over. Is it okay for us to move into that 2-bedroom, 1-bath temporarily while we're waiting to evict him?
if I had my druthers, I'd say no, but legally, I don't think there's any problem with it. You might even tell them, hey, we're just moving in temporary because we need to have a 3-bedroom and this is only a 2 or
Right.
whatever the story is. Yeah, I mean, I'd probably, for just how it would look in a court of law, it'd probably be better if you didn't. But again, I think it's very easy to explain what your situation was. And with that, Gabriel, I'm
Thank you.
going to say thank you. I'm going to go back to Al. Maybe Al, if you could unmute yourself. Are you there, Al? There you go. Nope. Okay, Al's having technical difficulties here today, so we'll try again next week with you. Let's go to Paul DeJoseph. I'm going to ask you to unmute yourself. Paul DeJoseph.
Oh, hi, Mr. Block, Paul DeJoseph.
Hi there.
Hi. Something just came up. I received a note from my manager that one of my tenants who doesn't have a car, rents one periodically, is allowing another tenant to park in his space. Do I have any worries there?
I don't think you have any worries. I mean, you'd have to check if you didn't want that to happen, you might want to check your rental agreement. Generally, the rental agreements are going to say that you and only you are allowed to park in this space and you can't assign it to somebody else. But if it doesn't bother you, I don't see any additional harm. I mean, that tenant who's parking there also lives in the building too, so I don't see any harm with that.
Oh, okay. And then something that was brought up, I have a family who actually has been with me for many, many years. And when they moved into this apartment, their 2 children, 2 young girls, were underage, and they were not, they did not sign the lease agreement. Now they are, of age, working adults. And every time we have said we would like to, well, this was before Measure H, get a new rental agreement. They said their children didn't, they didn't want their children to sign a new rental agreement.
Yeah, that you can't force them. When you say Measure H, I'm assuming that your property is located in the city of Pasadena?
Yes.
Yes. Okay, yeah, you can't force them to sign it. So, I mean, they moved in, we were underage, so obviously you don't have kids under 18 signing anything. But I don't see any harm to it. They're proper tenants no matter what. Anyway, thank you very much. And we are going to move on to Lee Stadell. I'm going to ask you to unmute yourself.
Hi, Dennis. I have a single family in Fullerton. And I am renewing a tenant's lease for 12 additional months, but he's a very good tenant. He's been there some time, and I don't want to raise his rent. I mean, normally it would be easy, but in view of the Justice for Renters Act, I want to have a higher base rent that's the market rent on file. I don't want to do a temporary reduction. It'll be for the entire 12-month lease term. What should I call this? Should I call it a rebate? Should I call it a concession? And do I have to have him pay me the market rent and I give him a check back each month? Or how would you do that? And what would you call it?
Well, I got questions for you first. And that is, why don't you want to raise the rent to what you legally can get?
It's a personal issue.
Okay, so
I mean, I would take up the entire time if I
we're
told you
dealing with
so.
an ex-husband or something.
No.
And I've said this before, and I can't even believe I'm going to say this, but 50 years ago when I went to law school, I remember what a professor once told me, and that is that the law is not an ass. And on that basis, the law will look through the form to the substance of this. If you are going to do it, let's pretend you want to raise the rent. Let's just use some figures, and I'll tell you the best way to do it is, let's say you want to raise the rent and you can literally raise it to, let's pretend, $2,000, but right now the tenant's paying $500. So I would do a new lease for $2,000 per month, and I would have a little attachment to the lease or a little addendum to the lease, which says that for the months, the first month's rent's $2,000. For each additional months from month 2 to month 12, you're getting a $500 discount. This way, I think you've clearly established that the rent is $2,000 per month. So, and that's what it's going to say. But in the addendum, it says for months 2 to, and he does have to pay the $2,000 for the first month. But for months 2 to 12, I'm giving you a $500 discount. I think that's the best way to play it, Lee.
And what should I title that? Should I call it?
It's just addendum to lease. That's all.
No, but what do I call the clause? Do I call it?
Just write addendum to lease and start your paragraph, which says from months 2 to 12, I'm giving you a $500 discount, period. But by doing it that way, in my mind, you've established that the rent is $2,000 per month. So you're protected under Justice for Renters, assuming that disgusting law passes, which, by the way, everybody mark your calendars that you're going to go out to that ballot box or a poll, and you're going to vote for the no on that Justice for Renters. Anyway, thank you very much, Lee. We are going to move on to Sonia. Sonia, I'm going to ask you to unmute yourself.
Yes. Hi, Dennis.
Hello.
Hi. So my question has to do with, I have some friends, so they own a property in, Toluca Lake, single family residence. Now, you were talking last week or the week before regarding notice if the ownership changes or owners. My question is, we were talking, and it's held in two brothers. One of the brothers put it in his family's trust. So now the names of the ownership on the original rental agreement is different. And they want to extend the lease, which is going to expire like August 14th. So since the name has changed, do they also have to give notice? I would imagine give notice of the name change as well as we're extending the lease and all that stuff.
Okay, well, first of all, you're gonna do a new lease?
No, just the extension.
Okay, if you're gonna
of
do
the
an
lease
extension, if you're gonna do an extension of the lease, then in that lease, you should mark who the new owner is and have all those terms. You don't have to do a separate change of terms. Just put all that information into the extension to the lease and have the tenant sign it. Once the tenant signs it, then you've complied with the Civil Code Section 1962.
Okay, quick follow-up. They originally had also a grantor or on the lease agreement. Do they need to sign
A grand.
a guarantor?
Oh, a guarantor.
Yeah, sorry. Would they need to sign that form since?
Absolutely.
Okay, perfect. All right, thank you.
Okay, let's move on to Fred Morris. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello,
Got
Fred.
hello. Two quick questions. If I own my properties all under a trust, but I'm in escrow buying a building with the proposed 3% that probably will pass for rent control effective January, and you know how you can get an extra 1% if you're a small landlord. If I put that new property under the LLC, would that qualify me as a small landlord? And also in regards to that month deposit. So if I'm buying it buying it under the LLC, would that be okay having it this way since I have everything else under my family trust?
Okay, well, first of all, I feel like a dentist in this phone call. But
I'm sorry.
but notwithstanding that, are you talking about the city of Los Angeles?
Yes, sir.
Okay, whether it's in an LLC or a trust, your rent increase is the same. By the way, effective July 1st, if you haven't raised the rent for RSO properties, you're entitled to a 4% rent increase. So if you haven't raised the rent for your RSO properties, but how you hold title is irrelevant to how much you can raise the rent.
No, I get that. I already raised the rent in February. What I'm talking about is the new the new law that was 2 weeks ago proposed by the LA county supervisors, where if it gets approved, it's going to be 3% cap instead of 4%.
Well, the county has nothing to do with the city of Los Angeles. The county only has to deal with unincorporated areas of LA County. So if the supervisors, and nothing's passed yet, but if the supervisors are now saying 3%, oh, I see. I think they had something about luxury units where it could go up to 5%, but that had nothing to do with, I think they had to do with how much rent you were charging, not what entity is purchasing that. But again, this law hasn't passed yet, so it's hard for me to comment on it.
I got you, but they were saying also in the proposition, if you're a small landlord, which I think you own less than 10 units, you can go an extra 1%. So that's what I was asking. Since everything I own is under a trust, if I'm in escrow, if I put it under the LLC, because my LLC doesn't have any properties under it.
That would be considered a separate owner then. You need to have, assuming this law passes, okay, and I haven't really studied it, but assuming it did pass, I would think that you'd have to have it all under one umbrella. But again, I really don't want to comment on it because it's silly to comment on laws that hasn't been passed yet. In any event, thank you very much. And we are going to move on to Jessica Yang.
Hello. Hey, thank you, Dennis.
Hello, Jessica.
Hello. A question. Single family home, the city of Eastvale, Riverside County. My mom and I are both the owners of the home. We rented to one tenant last May with the condition that we're going to move back in 1 year. So June of this year, and are therefore ending the rental agreement with the original tenant. So during this time, original tenant subleased our home to 10 people. Yes, 10 people, that's 2 families. And this is unauthorized subtenancy because it's written in the rental agreement. So tenant already moved out, and we as owners are back in the house because we're like, hey, we told you we're going to be back. Subtenants are still here. They don't want to.
Did you say you already moved back into the house?
Yes.
How did you move back into the house with strangers in their house?
Well, we kind of know the tenant, like original tenant is my mom's acquaintance. So we were like, hey, look, your tenancy ended. So we have nowhere, my mom had nowhere else to go. This is like her primary residence. So
So
she,
the illegal subtenant allowed you to move in.
that's correct. That's correct.
Well, you know, 48 years in practice. I've never heard this one.
This one's a doozy. This one's a doozy. We already got a lawyer. He's like, I've never heard this before.
Well, that makes two of us. So, so you're living in the house. Have you accepted rent from this stranger?
Absolutely not. No, no. So no rent.
Okay, so I would do in that situation, I would serve him, I would consider him an unauthorized subtenant. I would serve him with a 3-day notice to quit based on the fact that the tenancy terminated when the other tenant left. And you have no right to be there. You're not my tenant. I've never taken any rent from you. The strange part is that you're living there, but I don't think it really changes anything with the law. So that would be a 3-day notice to quit based on a subtenant under the code 1161 Code of Civil Procedure subsection 1. And
Okay.
thank you very much. A very odd question. Moving in with strangers. I don't know about that, young lady. So you know what? Let's move over to a bird. Robin, I'm going to say hello and unmute yourself.
Hello. I have two questions. The first one is just about your office. I've accumulated 22 properties over the last 15 years. And I have a list of about 9 questions that are just scratching the surface. I want to be able to hire your firm for a couple of hours to come in and meet with you and review several of these tenants. They're all filled with tenants. Some are multifamily. They're all in LA. And how do I go about doing that?
It's really simple. Just call the office and tell them you want to set up a consultation.
I did that 7 times and have not received a call back.
Well, our phones are busy, but I've said this out in previous shows. If you want to get to me directly, call between 7 to 8 a.m. only and hit my extension as soon as the recording comes on, which is extension 1001. You'll get me
Okay.
immediately and we can set that up for you.
Great. My question.
But 7 to 8 only, Monday through Friday. If you call at 6:59, I'm going to violently hang up the phone.
Okay, so 7 to 8.
And then
6
you'll get me,
days-
and then we can get you in on an appointment.
Okay, and that's 5 days a week, did you say, or 6?
Monday through Friday.
Monday through Friday. Okay, the question that I have for you is I have a tenant that moved in 3 years ago in a single family in North Hollywood. They did not disclose that they had a childcare business. And they got a 3-year lease. And the lease is coming up in October. One of them moved out, but the other one is continuing to operate. I've had to do several alterations because I'm afraid of the liability. They have $1 million liability policy, but I've been told that I need to get an umbrella policy that's 10 million in case some little boy falls down and dies. I guess what I want to know, I'm not going to renew the lease in October. I'm afraid of this new law that could pass in November, and I want to figure out how to get the tenant out. I understand there are rules about childcare that make them untouchable.
Yeah, let me slow you down because the question's going a little bit long. Number one, unfortunately, in the state of California, if somebody wants to start a business in your house and that business is daycare, you have no option but to allow it. They do have to have a license. They do have to have insurance. And it appears in your situation that they did. So you're stuck with them. You can, once the lease expires, the best way to deal with that, since this is a single family residence, you can't just ask the tenant to move at the end because we're under this just cause ordinance for all residential property in the city of Los Angeles. But the easiest thing to do would just be to raise the rent. Or you can do a renovation eviction. I want to renovate the premises, so you're going to have to move. One of those two would be the best way to go about it.
And you said market rent. Who establishes what the market rent is?
Well, I would go to a website that I always recommend that I have no affiliation with, but I pay for it myself. The website is called rentometer.com. You get 5 for free. I pay for it because I really like the service. And you can see what that is. And I'd go maybe a little bit higher. That might be incentivize them. Or maybe you just want to renovate, put a new kitchen in the damn place, and you'll be able to ask them to move. You don't have to allow them to come back, and you can raise it to whatever you like.
Thank you.
Thank you, sir. All right, we're moving on. How's our time? Oh, we're doing pretty good. Jack Sheridan, say hello.
Hello, Dennis. And
Hello.
it's Jackie.
Is it Jackie?
Yes.
Okay, Jackie.
I really appreciate all your help. It's amazing that we have someone like you. And I'm asking, I guess, a silly question. I'm new to all this, and I need to do a credit check on a guy who's applying for, and I don't know how to go about it.
Okay, well, every time you ever lease a property out, you have to run through a credit check. Any of the apartment owners, apartment associations all run them for you. I deal a lot with the Apartment Owners Association, so you might want to call them. There are other associations, but I do like dealing with them. And it's not a bad issue to join the association because they have a wealth of knowledge, not just from me. But definitely you can go online and just do a credit check anyway without going through the associations, but I do recommend them. Anyway, thank you very much. And let's see who is next here. Bear with me 1 second. I gotta find you. Well, I don't know that I can pronounce this, but it looks like Maria Laika. I'm going to ask you to unmute yourself. Maria. Ask you to unmute. No.
Yes, I'm unmuted. Yes. Hi. Sorry. Thanks, Dennis. It's
Look at-
Mary Alice, just Mary and Alice put together.
Okay.
Okay, I typed my question in the chat. I'll do it as quick as I can. I have my best friend who had long-term tenants in her single-family house in the city of LA. They were great. Everything was fine. She had a roof leak in February during our storms. We hired a roofer right away, got the roof fixed, put some attic insulation in. The tenants have decided we offered them the chance to leave, but they decided they would stay and put up tape and live downstairs. Everything was fine. They've now decided they were so grievously inconvenienced by the dust and the nails in the driveway, even though we sent cleaners to rectify all that they want $42,000 for their inconvenience because they know that she's got an ADU that's not permitted on the property, and they're threatening that they'll take her to court and get her then she'll owe all the back rent of $600,000.
But they're not in the illegal ADU.
No,
So-
they're in the
That's like saying, and I know you have an illegal unit in Utah, so I'm not going to pay the rent here. That doesn't make any sense.
well, it's the same house. It's an upstairs downstairs. So it's in their they're
Oh,
together.
so it's not a separate structure.
Yeah, and they
Yeah.
knew when they moved in.
It
They
doesn't
knew when they
matter what
moved
they
in,
knew
yeah.
that they moved in. That's irrelevant.
Okay, so she's got an architect that's working on getting it permitted. We think she can have that
Is
done
the
before they can
upstairs
file a case.
rented?
But upstairs and downstairs are rented. The downstairs tenant's cool. The upstairs ones have got their friend, the attorney, sending us mean letters.
Yeah, well, I'd have to take a look at those letters to really give you a better opinion on it. But at first blush, this was only one unit, so they're not getting the full house, right? They're only getting partial of the house. The house this is a single family home that you've carved up into 2 units.
Yeah, they've got an upstairs and downstairs and 3 bedrooms on their own. It was what, they liked it and wanted it. My question really is around what administrative law judges are ruling these days, knowing that the city wants to encourage us to get these ADUs and get them permitted. Are they really going to come down on her and tell her she needs to, if they
Well,
really
they
did?
they don't have to give any money back. What I would do is I would start an eviction based
Yeah.
on the fact that it's an illegal unit and therefore we want you out. You're going to have to kick out one or the other. I don't know how LAHD, the Los Angeles Housing Department, is going to play it. They'll probably say that the upstairs is needs to move. And then this way, once he's out, you'll put the whole unit back. It's now a single family residence. And now if it's a single family residence and the people on the bottom have the whole use of the property, guess what? I can now serve you a rent increase for the full rent because it's now a single family residence. So you're not.
I think she prefers to split it. I think, you know, it's set up really well to be an
Or,
upstairs and
okay, well then,
downstairs. Yeah,
if you can get it legal, get it legal. And then
right.
the other tenant has nothing to squawk about. So that's what I would do.
Okay, great. I really appreciate your help. Thanks, Dennis.
You take care. Okay, we are moving on to, well, we're right at the time. I'm going to take one more and let's go on to Brian Naomi. I'm going to ask you to unmute yourself.
Hi,
Brian?
Dennis.
Hi. I mean, for the record, everybody, I take the meeting personnel in the order that they came in. So if you get in quicker, and I do try to get through them all. In fact, this one, Brian is out. So if I didn't get you this week, ladies and gentlemen, get me next week. And Brian, what's your question?
So my question is this, single family or condo, not in County of Los Angeles, but just statewide. I just have some relatives, mom and pops, who have done old leases. Are those subject to the statewide rent control or are they not? In other words, we never gave out the advisory saying this is not subject to statewide rent control.
If it's not subject to statewide rent control, if you didn't have the exemption in the rental agreement, first of all, was the rental agreement entered into prior to November 2020?
Yes.
Okay, so you can just serve the notice that this is exempt. That form is on my website. So you're not doing the addendum and not adding it to a rental agreement. You're just going to serve that notice. By serving that notice, you have now complied with the law. You can do it afterwards as long as they moved in before November of 2020. Now, even if they had moved in after and you didn't have it contained in your rental agreement, you can still raise the rent to whatever the hell you want. It's not subject to rent limitations. It might be subject that you need cause to evict. For example, I can't ask you to move because I'm selling the property. But again, I don't care where the property is, what's in the rental agreement, who owns the property, a corporation, it doesn't make any difference. Single family homes, townhouses, condominiums are not subject to rent limitations, but you might be subject to the good cause. But you're golden. Go to my website. There's a button that says statewide forms. You'll see the one that says notice exempt as opposed to an addendum to the rental agreement.
Does your answer change if the rental agreement was entered into after 2020?
Yes, it does. Then you're now subject to it. So you would have to have cause to evict. But again, you're not subject to rent limitation.
Got it. Thank you.
And with that, ladies and gentlemen, we have finished our meeting for today. I do appreciate everybody coming out. We're going to do this next week as well. And you guys have a great weekend, and I am off.